Hello and many thanks for joining us on this edition of People, Politics and Power. I am Imoni Amarere. The march towards the 2023 elections has begun in earnest with the commencement of party primaries for tickets to state houses of assembly and the House of Representatives. The others, that is, Senate, governorship, and presidential primaries, are expected to follow in the days ahead. For some, the intra-party contest is perhaps the most crucial, especially in states where their parties hold sway, which is why such aspirants throw everything into securing the party's ticket. However, the confusion over the status of the Electoral Act 2022, which governs the conduct of the primaries, is yet unresolved. About 2 weeks ago, you will recall, the National Assembly hurriedly passed an amendment to the Act to accommodate automatic or statutory delegates' participation in the primaries. The lawmakers specifically amended Section 84, subsection 8 of the Act to guarantee the participation of statutory delegates in the primaries. It still beats the imagination of many how the lawmakers successfully schemed themselves and other elected officials out of the electoral process at the party level, given the long time it took them to consider and pass the bill into law. President Muhammadu Buhari has so far withheld assent to the amended bill, which was transmitted to him on May 13, 2022. The expectation was that the president would give his assent before the commencement of the primaries, congresses, and conventions of the parties. But since this did not happen, the expected number of delegates may be affected, as the subsisting Electoral Act clearly excludes the statutory delegates, which include the president himself, the vice president, state governors, and their deputies, senators, members of the House of Representatives, members of state houses of assembly, and all former elected lawmakers, amongst others. Ironically, these are the same set of people that the aspirants, particularly the presidential aspirants, have been chasing after and showering with cash and other inducements from state to state in their so-called consultations. Some members of the National Assembly argue that the party constitutions already provide for these statutory delegates, and they therefore do not need the amendment in the Electoral Act to operationalize it. If this is true, why did the lawmakers bother with the amendment in the first place? Since the primaries process has begun, using the template provided by the subsisting Electoral Act, which of course recognizes only ad hoc delegates, would it be lawful and legal to adopt another template in the subsequent state congresses and national or presidential conventions if, and there's a big if there, if the president were to assent to the amendment before then? Can two different laws govern the same process? How is this probable scenario likely to impact the entire political process? Is there more to the presidential reluctance in assenting to the amendment? These and many more are the questions we shall seek to answer on the program today. Stay with us. We will get to meet our guest analysts as soon as we return from this break. All right, thank you so much for staying with us. People, politics, and power. And we are taking a look at the Electoral Act 2022, the proposed amendment by the National Assembly and the reluctance or refusal of the president to assent to that amendment, and how this is impacting the ongoing party primaries of the various political parties in Nigeria. And I'm joined in the studio at this time by Mr. Gbenga Owa. Mr. Owa is an Abuja-based legal practitioner and a public affairs analyst. Thank you so much for joining us, Mr.
Thank you,
Gbenga Owa.
Imoni, and good afternoon, viewers.
Well, also joining us in the studio right now is Max Oga. Max Oga is also an Abuja-based lawyer, an Abuja-based legal practitioner, and a familiar face on this channel. Of course, he's also a public affairs analyst. Thank you so much.
Thanks for having me.
Yes, welcome. Right. Mr. Owa, so let's begin this way. Did it come to you as a surprise that after the Electoral Act took so long to be passed in the National Assembly, with all the controversies that surrounded that piece of legislation, that the lawmakers could in the first place omit such a sensitive item in the law?
I liken the quality of leadership that we have at the National Assembly, and sometimes the executive and the handlers of the president and his advisors. So the tale of a pilot or a passenger flying a plane, and usually you don't see the pilot or you are not in the cabin, and usually when you are flying there are some bumps here and there, but when you have sharp descents and some crazy moves inside the aircraft, I mean, this is a plane flying at 800, 1,000 kilometers per hour. You probably may start fearing that your handlers or your pilots, you wonder if he really, really knows precisely what he is doing. And you start shouting. And occasionally you hear from the cockpit and says, oh, don't worry, everything is okay. Now, back to the real question that you asked. Now, let's look at the process. We have over 400 honorable men who passed this law at the beginning of this year. 400. Some of them have legal assistants. And you also have legal advisors at the presidential arm, you know, the Attorney General's office. And just take a little bit of interrogation at the process of lawmaking. I think this is a serious and a huge joke that assaults the sensibilities of Nigerians who elected these people into governance. We've not come into the credibility of why the amendment in which everybody is dashing helter-skelter about. But this law was passed in February. Section 84, subsection 12 is passed in February by the lawmakers who are worst hit by its adverse effects. And then 3 months later in May, you are hurriedly within 1 week, I mean they deliberated within 1 week and passed an amendment saying that there was a slip. Should we not really ask if they are justified, if the Nigerian taxpayers' money that pays them is justified? That's the first. So we've seen a number of things that has happened, but this is the crux and the height of it that should make us question the entire process of lawmaking, which is a serious, business of state. The Constitution establishes the National Assembly in Section 4 as the principal organ of government that makes laws, and it passes through the executive, and the president signs it, and it becomes law and becomes operational. Forget the constitutionality and the process and all that. So I want to say that the first thing we Nigerians and Nigerians who elected them into office is to call them into question and rebuke them hardly and harshly and say, you have not done well. And I want to use this opportunity to say that, look, it is a terrible insult on the entire lawmaking process. It calls into question the seriousness of what is happening in the National Assembly and in the office of the President of the Federal Republic of Nigeria. It's a national embarrassment, and every right-thinking Nigeria should be embarrassed. These are funds made for taxpayers. This is not supposed to be a joke. So the entire process is sad, first of all.
Yeah.
Yes.
Mr. Oga, apart from the lawmakers and the executive arm, every other Nigerian, and there were many of us, civil society, the political parties themselves, were supposed to have engaged with this piece of legislation. And we did engage with it. And somehow, this particular amendment slipped the minds of everybody.
Well, I want to look at it from the point of view that perhaps this is a cleansing opportunity, an opportunity created by providence for us to cleanse the system, because I cannot rationalize why people will create a stumbling block for themselves, the lawmakers, because a good number of them are contesting. Perhaps because of what we've gone through as a people, God wants to deliver us. That's why He allowed a mistake like this. Everyone only looked at this from the point of view of political appointees being stopped from participating in the process. The reality has just dawned on all of us that beyond political appointees, ministers, SAs, commissioners, chiefs of staff, and all of that, that even the lawmakers,
Yes.
the 469 people who sat in both chambers of the National Assembly to pass this law, that even they themselves are affected by this self-imposed limitation or stumbling block. By way of a way forward, I want to suggest that moving forward, since we have all come to terms with the fact that the Deputy President of Senate and the Deputy Speaker of the House are traditionally chairmen of the Constitution Amendment Committees of both houses, that moving forward, that position should probably be restricted to lawyers. Because if the chairman of a Constitution Amendment Committee is not a lawyer, he would depend on some other people for his work to be done. And the people he's depending on may have mischievous intents.
The Electoral Act was not the handiwork of the Deputy President of Senate and the Deputy Speaker.
No, I know.
This was the INEC committee.
I know. But look, before the meal is passed to the dining table, someone is responsible for the preparation of the meal. Right? Yes, we have committees in charge of INEC in both houses. But there's someone, or there are some people, two people, who superintend over the process in both chambers. Yes, the committee should be there, but I'm saying, henceforth, the heads of the Constitution Amendment Committees in both houses, beyond this issue affecting INEC, it is a constitutional issue. So it has to do with constitution. It is not necessarily, but law making generally and amendments generally have a constitutional flavor. So if we put ourselves in a position where those who should be directly in charge are lawyers who are knowledgeable in the implications of legislations made by the legislature, I think we will reduce incidences like this moving forward.
What do you then say of the political parties themselves who are directly affected by this, who have legal advisors and have individuals who are in their employ who are also legal minds who did not spot this omission in the first instance.
That throws up another issue. As I speak with you, the chapter legal advisor of the All Progressives Congress in my local government, is my cousin. He's not a lawyer. And he's not anything close to a lawyer. If he has any closeness to the law, maybe myself and some other of his cousins who are lawyers. But he advises the party on legal issues. So we may have people like that who are non-lawyers. Politicians just feel that, oh, look, people should occupy these positions. People who are not lawyers. And I say with a deep sense of responsibility and at the risk of being immodest, that it is not everyone who has a law degree who should be given a task to explain to someone the implication of a particular law. Anyone who interfaces with the law on a daily basis has the privilege of knowing the law better than someone who studied the law, made the first class at the LLB level and the BL level and has never practiced law. There's a difference. Just like somebody having a degree, a certificate in journalism is not, without practicing journalism, cannot be put on the same platform with someone who has a mere diploma in journalism but is involved in the daily practice of journalism. So our political parties moving forward should look at the quality of persons they put in positions to advise them legally. Oh yes.
Okay, Benga, the rest of us, lawyers, civil society, who engaged very seriously with this piece of legislation and at every point pointed out one or two things about that were considered to be shortcomings of the legislation and suggested ways to make it much better. Did all of us not fail in spotting this omission?
At the end of the day, the buck constitutionally stops somewhere. And that's basically what we are saying. That the entire process of legislation is a serious business. And like my colleague here
that should engage the attention of everyone who deserves good governance.
The attention of everyone who deserves good governance. But more importantly, constitutionally, by law, the people that are charged with the business of lawmaking is the National Assembly and the executive. And I'm happy, quite honestly, that taking a look at it, the president has said, oh, look, there's a lot of confusion. I need to take it easy. Don't stampede me. And I'm happy that he is taking it easy. And he said, look, I'm making consultation. Now they are trying to railroad him. Oh, leave the man, let him get, wider consultation. Because what's been happening, it's a little bit disturbing. On one hand, you invoke the jurisdiction of the Supreme Court to interpret the law. On the other hand, you are saying, no, let me take a look at it very well. So I think we need to take a look at this, because there are problems. It's like we are in between the devil and the deep blue sea. If he signs it right now, there are implications. There are serious implications, because party primaries have commenced. Some people have commenced that entire process. Will it be retroactive? If he does not sign it, there are consequences. And so when you look at the state in which we are in, I believe that somewhere, in the midst of all this confusion, we're taking notes and we will learn. But the process, I'm sure INEC is there, and they are not going to bulge in their timetable. And let the parties sweat it out. Talking about consultations.
Yes. Yes, shouldn't the executive, particularly the president, have consulted much more widely before appending his assent to this piece of legislation? And at that point, should he and especially the Attorney General, because
Yes.
you recall that the Attorney General raised some objections to some clauses
Yes,
in the bill,
he did.
which of course included section 8412, upon which the president wrote to the National Assembly later on to please to expunge, which the National Assembly turned down. But the Attorney General and the legal team of the president did not see this, or did they see it and deliberately did not bring it forth?
Whatever it is, the president signed it. He's the president of the Federal Republic of Nigeria, and every signature, every assent to law by virtue of the provisions of the Constitution, he takes responsibilities for it, not just his not his Attorney General. The Attorney General is basically an advisor, you know. So he should take responsibility for a law signed in February that now becomes a stumbling block to the political process 3 months after that, a law in which is clearly unconstitutional, and the courts have declared it unconstitutional, as it were. You know, so I think having made that mistake. That's why I'm saying that, look, it's important that he sits back and make a wider, even the Supreme Court sometimes, or the courts of law sometimes, when issues are brought before them and they have to take final decisions, they call lawyers who are not necessarily stakeholders in the, we call it amicus curiae in law. And they say, oh, come on, write a brief on this, write a written address on this. They call top lawyers, constitutional lawyers, and stuff like that in our jurisprudential history. And so I want to say that the step the president is taking in being reluctant right now is a wise step. And so let him get all the consultations. He has 30 days, by law, he has 30 days to make a decision, or whether to assent to it or to refuse, even though every day, every minute, every second in the political process counts. We know that. But at the same time, his name is, his posterity will judge this president. And I think that's important, that every bill that he assents to is done with a great sense of responsibility.
Mr. Oga, do you share that position? Do you think that the president should take a lot more time to look at this amendment while the primaries of the political parties are ongoing?
No, I think he said it all. There are head or tail, there are implications. If he rushes into it, what happens? Some candidates have already emerged. The PDP started its, or conducted rather, its House of Reps and State Houses of Assembly primaries yesterday. Some people have emerged. So if the law is signed today, are you going to apply it to political parties that are yet to hold their primaries for State House of Assembly and House of Reps? If you do that, that means you are being unfair to the PDP, which has started the process. So we are already in the mess. It's for us now to take time and make sure we come up with something qualitative. Like people say to us, direction is better than speed. Knowing the direction you're going to is better than speeding to an unknown direction. So for the future, let's have something qualitative that will guide the electoral process.
That of course takes me to my next question, which is in a situation, a very probable situation where the president assents to this amendment in the middle of these primaries, what happens? Can two laws govern the same process?
Not at all. Beyond that, there's a principle in law called lis pendens, that when a matter is pending in court, no party to that matter or to that dispute should take any step that will be prejudicial to the interest of the other party. Now, we are saying we want the Supreme Court to weigh in on this. So, if the president goes ahead to assent to this amendment, that means the Supreme Court has been put in a position where his decision at the end of the day will amount to nothing. So I said this to say that we just have to wait. In addition to saying we cannot have two electoral laws governing the same election at the same time. There should and there must be one electoral law applicable to everybody across board, so long as these primary elections are concerned.
So, Benga, what is likely to happen is that this process, these current primaries, ongoing primaries, will be governed by the subsisting Electoral Act.
Yes.
But if the president were to change his mind and sign it into the amendment into law today, what happens?
Well, it's very clear that existing law. Let's ask the question right now. What exactly is the existing law that INEC works with? Of course, it's both the Constitution and the Electoral Act. INEC's regulation says send in the names of
your delegates.
Your delegates. You know, there's what you call law, and then there's practice. Sometimes there can be a world of difference between law and practice. So in practical terms, INEC is constitutionally the umpire of all electoral process. And they have come out in the discharge of their constitutional responsibilities and functions to say that, look, give us the lists of those who are going to be attending your delegate conference. So if APC, for example, or ANPP, or whatever the party is, gives the names of political appointees, INEC reserves the rights to say, no, we are not going to recognize this. Can you kindly delete the names of all lists number 1 to this? And that's the law we are basically going to be, working with. When we are all done, you can go back to court to say that, oh, the election, the primaries was faulty for being unconstitutional. Let's leave that to the courts. But in practice, what is INEC going to do? That's the question. There's somebody who is head of legal in INEC who is going to be advising the INEC chairman that, look, once this party's primary commences, and the scenario you are painting about the president either assenting or withholding his assent or whatever the game, the way it turns out or it's being played out. Somebody is going to be advising INEC. And whatever it is INEC does is practice, is law in practice. Is their understanding of the law. That's it. That matters in determining the way the elections, the pre-election elections go on. And so I want to say that it's like we are basically between the devil and the deep blue sea. And after this whole learning curve and learning experience, my hope is that both the civil society, the legislatures, the president, and all stakeholders in lawmaking process will keep their eyes down, see that, look, you should not disenfranchise a whole group of people. The Constitution does not allow it. It's very clear. It is not ambiguous at all. But you know what? Just like my learned friend here has said, there are many people who have been disenfranchised. Is it because these people are more important? Are they more Nigerians? Are they more Nigerians than disabled people? Are they? That's the question a number of Nigerians on the streets are asking. Are they more Nigerians than people who were disenfranchised because they could not see ballot papers in 2007, 2011, 2015, 2019? The aged? Look at the speed at which they amended what bothers them. I mean, the common man on the street is watching. And then you have PIB on their table for how many years?
For decades.
You have the Disability Rights Act. Over there, it took 11 years on their table before attention was given to it. And several laws that affects the common man, from Katsina to Umuahia, affects the common man, is taken from the back seat. And so I think that it might be providence, like he said, unconstitutional, clear, but who knows? Maybe by the time you edit away this whole crop of political leaders, and maybe a new crop that comes, we may have an overhaul of a leadership system, and with Nigeria may just be a better way for it.
Mr. Oga,
Yes,
there's another angle to this, and that is the argument that has been put forward by some of the lawmakers themselves, to say that, look, the constitutions of the various political parties recognize these statutory delegates, and that the parties should go ahead and adopt the provisions of their political parties in the conduct of these primaries, even though these statutory delegates are not provided for in the Electoral Act 2022.
Well, I will not buy that argument, even if I'm expected to pay with counterfeited currency, which ordinarily will not cost me anything. I will not buy that argument. Now, there are three main laws that govern elections: the Constitution, the Electoral Act, and the INEC guidelines. The constitutions of political parties cannot take the place of INEC guidelines or provisions of the Electoral Act. If the Electoral Act has said it is only elected delegates, 3 per ward, in the 774 local government areas and area councils in Nigeria that are qualified to serve as delegates, whatever provision we have in the constitutions of our political parties cannot override this. And like he said earlier on, the regulator of our elections, the Independent National Electoral Commission, has come up with guidelines. They are working with these guidelines. Whether they are right or wrong, it is their discretion they are exercising. And the law is very clear that you cannot say the exercise of discretion by Mr. A is wrong because you would have done things otherwise. No. INEC has said these are the people who are qualified to be delegates. They must all be elected, and 3 per ward. Nothing can change this. Nobody will at the end of the day approach any of our courts to interpret any provision of a political party's constitution vis-a-vis who qualifies as a delegate for purposes of party primaries. What people will do is to approach the courts with the interpretation of the provisions of the Electoral Act. And we know what is extant at the moment. We are looking at the law as it is, not as it will be upon the assent of the president, which assent we are not even sure of. So INEC is following the law as it is now. INEC has come up with guidelines. Nobody has gone to court to challenge the INEC guidelines. Any political party that feels that its constitution takes precedence over the Electoral Act or the INEC guidelines should approach the courts now to say no. INEC must follow what we have in our constitutions. I want to wrap up this my answer with this, with a question: is INEC governed by the provisions of the constitutions of our political parties? The answer is no. The constitutions of our political parties govern members of the political parties and the affairs of the political parties, not INEC, the regulator.
Benga, the argument can be extended to say, look, the primaries are the affairs of the political parties. And that INEC, in registering these political parties, registered and recognized their constitutions.
Even the law recognizes the constitution of the political parties. And that's not the point that my colleague here is making. There's a place for the constitution of every political party. You know, right to the Supreme Court has said, for example, if the constitution you subscribe to of your political party prescribes how conflicts are settled, it's important that you go through that process before you even approach the courts, the Rivers State scenario. Now, but what he's saying, and I endorse completely, is that where there is inconsistency between the constitution of a political party and a law, the electoral law particularly and specifically, which one should bow? It is certainly the constitution of the political party. The political party is just an association of like-minded people, and their constitution cannot set aside or overrule or override the Constitution of the Federal Republic of Nigeria or the electoral law. Just like the electoral law cannot override the Constitution, because the Constitution is called the ground norm in law. And basically any part, any portion of the electoral law any portion of the electoral law that is inconsistent with the provisions of the Constitution should be void. But let me also say that let's not forget the mischief that law was actually trying to cure. Let's go beyond the rhetorics and the academic discussions. I believe that the insertion of that whole thing is supposed to say, look, let's ensure a level, which is why the civil society actually endorsed it. Let's ensure that the man who is in office, who is in public office, does not use public funds, public infrastructure, public goodwill to skew the political process in his favor. We know in practice, we've been on democratic race since 1999. This is 23 years now. So looking at the entire process, let's ensure that the key stakeholders, the frontline trustees of our Commonwealth, don't use our Commonwealth to perpetuate themselves in office and thereby limit the rights of the ordinary Nigerians, as it were. Let's ensure that we limit all that. So they are not saying that, look, you should not run. You understand? They are saying that, look, sir, if you want to run, there's no problem about that. But can you drop that office so that you create a level playing ground? I think conceptually, the idea behind that amendment is noble. There is in interpretation of law, there are different rules of interpretation. There's one we call the rule of mischief rule of statutory interpretation. In other words, that the courts will look at what exactly is the state of the law before this, and then they will now ask second question. They will say, what exactly is the legislature really trying to cure? What mischief? So there is a mischief that has been observed. That, look, the delegates, who are statutory delegates, turn out to be the sole custodian of our collective will, and they box us to a corner where our right to choose our leaders is actually limited. And so they say, let's do something about it. The only problem was that they did not inject sufficient constitutional, intellectual, and legal engineering into the entire process. Otherwise, I think it's a noble stance.
That may have been true, Mr. Oga, with political appointees, but with elected representatives, how is that mischief cured here?
Yeah, that's why I said
that is the exclusion.
No, that's why
of
I said
elected
they did not
representatives.
inject enough. There's a way he put it. Now they ought probably
enough
to
intellectual
have been a
engineering. Yes,
they ought probably to have been a proviso to that section, that political appointees in this context mean A, B, C. But now all of that is left open. So if I want to undo you, I interpret it the way I want to interpret it. And for now, INEC sits on top of the table. Whether some people in INEC are acting based on influences from somewhere, we cannot say. But INEC is on top of the table. And INEC has said it is only elected, democratically elected delegates. I give this advice for free. I think this is the time for the political parties to probably go to court. To say no, an elected member of a state house of assembly, an elected member of a local government legislature, an elected member of the National Assembly is not a political appointee. And all of that. But everybody is quiet. And by the time we are done with the primaries, based on the guidelines INEC has released, there is nothing anybody can do.
Who has the locus, as you lawyers put it, to approach the court to interpret that now?
In my opinion, the political parties would have the local standard to do so. Those who are affected, every member of the National Assembly will have the locals. The National Assembly as a, okay, but I don't know if the National Assembly as a body, having made the law themselves, I don't know if as a body, if they can go to court to say, because that will be blowing hot and cold at the same time. But individuals can. Individual members of state legislatures can approach the courts to say, no, we cannot be shut out in this manner. Because if you look at it, it is absurd that the president of the Senate, the speaker of the House of Representatives, the 36 speakers of the state houses of assembly, and all of that will not be able to vote for anybody who is seeking the mandate of their political parties. Learned Council, this throws up another issue. And know that right from the civic education, we are taught that for you to be qualified to present yourself for an election, that you must have the qualification to also vote. I.e.,
to vote and be voted
for. So if as a sitting senator, if as a sitting member of the House of Representatives, if as a sitting governor, I cannot vote for anyone in the primaries of my political party, am I then qualified to be voted for as a candidate of my party, perhaps seeking second term or seeking to move to the retirement ground, which is the Senate? This may not have come to the front burner now, but I tell you for free, very soon. Some people may take up this issue and begin to challenge some other people that, look, by virtue of section XYZ of the Electoral Act 2020, you having been disqualified from voting for anyone in the primaries, you are also not qualified to be voted for.
Is there a possibility that, even as we speak, that some individual or even a group could approach the courts and the court could grant their prayers to stop the ongoing primaries on the basis of this disenfranchisement? If it does happen, what happens to the entire electoral process?
Once there is a judicial pronouncement, judicial pronouncement setting aside the process, we'll all be bound by it. Particularly if it comes from the apex court. But of course, you know, it has to travel from the High Court, state or federal, through the Court of Appeal, to the apex court. So once a pronouncement comes from the apex court that certain people have been excluded and that is unlawful and all of that, then we'll all go back to the drawing board.
So could this be a possible ground to truncate the entire process?
You know, Imoni, you know what comes to my mind when you asked the last question? Justice Ikpeme's June 12. You remember the June 12?
Of course.
And we learned that, you know, yes, Justice Ikpeme's
ruling,
midnight ruling that truncated
at the instance of Francis Attorney.
Exactly. Yes. So I think the judiciary, after that incident, has also come up with certain unwritten policies and guidelines when issues affect public policies, like general elections. I think that it will be, there is law and then there is general judicial policy, as it were, that keeps the institution of the judiciary above board and as also a responsible third arm of government to ensure that our democratic process is not thrown into confusion. So I think that I don't foresee a situation where the entire process of democracy will be truncated again. We've learned, I believe we've learned our lessons. And talking about the scope of those affected, I think the wordings of that section 84 is persons are appointed into public office.
That's 84.12.
Yes.
The amendment deals with 84.8.
Exactly. So it talks about persons appointed to public office. So the question is, who are those persons? Section 318, which is the interpretation section of the Constitution, makes it very clear. And elected persons are included in Section 318 of the Constitution, because it's not left, it can't be left into space. The Constitution clearly defines who is a public officer, persons elected into public office. And then it says very clearly, it includes members, staff, and members of the National Assembly. Those are the words. It lists, it says any person that is uses the word in any capacity is in the employment of the federal or state government. And this includes, and then it gives us a list, the president, the this, the that, and then it's one of the sections there in that list is the staff of National Assembly, or basically is a staff of members. So it's very clear that the members of the National Assembly and the houses of assembly of the different states, the 36 states, are all inclusive in the scope. They are all embraced and captured in the net of prohibition. The only thing, like we said, is that there is the Constitution has already spoken in Section 66, 107, and in number 137 that, look, these are the persons that are disqualified, and these are the grounds for disqualification. And it mentions very clearly that if you're a public officer, you resign within 30 days. Very clear. So obviously, if this Constitution has been silent, it will have been a different thing. The Constitution was very clear.
This is clearly a new twist to the whole argument and to the new discussion. If members, elected members, are included in that section of the Constitution,
they are.
And of course, there are other sections in the Constitution that seem to say otherwise. This must be the reason why a lot of people say the Nigerian Constitution lies against itself, is inconsistent in certain areas and all of that. Mr. Oga.
Well, I think when a document is too bulky, it creates confusion for itself. So perhaps moving forward, we should learn to be precise, in our laws. Make them as simple as possible, so that just any person can read and understand them. Right now, like you said, he has opened an entirely new chapter, Section 318. You said
318.
318 of the Constitution. So
318 sub 13. You said
no. It's just one section. It's just the interpretation act. It defines
so with that, I think we are limited. We are facing a rock. There's no escape way, because everyone is inside that basket, and that perhaps will affect the opinion I shared earlier on, that there could be a possible judicial intervention. But now the Constitution has said, oh, look, a member of the House of Reps is a public office. No, it's a political appointee. A member of the Senate is a political appointee. A commissioner is a political appointee. A member of the State House of Assembly is a political appointee. Then INEC is right. So that means the legal the people in the legal department of INEC probably understand these laws better than the people in the legal department of both houses of the National Assembly.
As a matter of fact, Section 318 clarifies and divides National Assembly from State House of Assembly. It is that detailed. It mentions members of National Assembly, staff and members of National Assembly, and mentions staff and members of State House of Assembly. So there is no confusion at all, and it has been judicially interpreted.
Now, if this position were to stand, I mean, what we have today, now that the primaries have commenced, if this situation were to stand, if the president were to refuse assent to this amendment, it means that moving forward, we'll be having only ad hoc delegates.
Yes, just ad hoc and elected.
At primaries,
yes,
party
yes.
primaries.
Yes.
Now, that will also mean that the parties may reconsider their INEC, and perhaps the parties will reconsider their position, because at the moment, it provides for only 3 elected ad hoc delegates per local government,
Per ward.
per ward. And that, of course, makes the number very small at the end of the day.
Yeah, very small.
Although some people have argued that that makes for...
That keeps our money.
Yeah, for good management of delegates and all of that, given what we have seen in recent times, those who have been crisscrossing the country in the name of consultations, doling out large sums of money to delegates, some of whom are unfortunately not going to be part of the process now. Would the parties have to reconsider maybe increasing the number of elected delegates from the ward, say from 3, say to 5 or 10, as the case may be?
I think apart from...
Would that make it more representative?
That makes it, I agree totally.
It is at the moment,
yes,
where you have the exclusion of all elected members of Senate, House of Reps, state assemblies, local government, legislatures, and all of that.
I think that would be the best thing to do. If you look at the way the parties, the democratic parties of the US, where we're getting our model from, you will, parties like the Republican Party, the Democratic Party, you will discover that they also operate the delegate system. And they have, just like we do, they have categories of delegates. And there is a lot of internal politics and politicking and negotiations that go at the different grassroots ward level that throws up who the delegate is. And then the number of political office holders and delegates who are already there are pegged at a particular number. So, for example, the parties come up with situations and say, oh, this even though you are statutory delegates, we can have more than this number of statutory delegates, and they are usually very small. The wisdom about it is that they don't necessarily determine the candidate that the party finally throws up at the general election. And
at the expense of the other delegates.
At the expense of the other delegates.
Okay.
Yes.
Right. Mr. Oga, one final word here.
Well, it is a learning curve for everyone. A lot of us have been taken by surprise, a lot of stakeholders. So let us learn well from this and avoid mistakes such as this moving forward. Let the political parties learn from this, then rejig the recruitment process of delegates moving forward, so that we have qualitative people as delegates who will have our destiny in their hands. Because at the general elections, where we say our PVCs are powerful, it is what these very few Nigerians decide that we will have to choose from. So let us have very qualitative people making that first round selection for the general elections.
All right, thank you so much. Mr. Max Oga is an Abuja-based lawyer and a public affairs analyst. He's been joined by Gbenga Owa, another Abuja-based lawyer and public affairs analyst, as we brainstormed over the Electoral Act as it is today and the primaries of the various political parties that are ongoing. As we speak, some political parties are actually conducting primaries for different categories of elective offices. We hope that lessons have been learned, and moving forward, this will enrich our electoral and democratic process. Thank you for investing your time with us. Gentlemen, thank you so much.
Thank you so much, Money.
And we'll see you again when we bring you a fresh edition of People, Politics, and Power. Bye for now.